Given the circumstances, at least as I understand them, and because I haven't.
Buckle up because this courtroom is about to explode. Welcome to Courtroom, where real-life drama unfolds in front of a judge's bench. Today's episode features Judge Simpson, a man who doesn't tolerate nonsense, and he's got his hands full with a defendant who thinks courtroom rules don't apply to him. From dramatic outbursts and legal confusion to disturbing accusations and a long criminal trail, this case spirals from defiance to disbelief. This isn't just a bond violation, it's a full-blown courtroom showdown. You'll witness raw emotion, shocking revelations, and one man's desperate plea for freedom, all while trying to outtalk the judge. And don't worry, we've got commentary on everything. The rulings, the legal traps, and the jaw-dropping behavior that could land anyone behind bars. So settle in, this case is about to get messy. Let's get into it.
Heard the entirety of the case or anything.
Right, exactly.
I'm
Problem
going,
cause or anything.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me?
The tension is already boiling. Judge Simpson makes it clear, this court is not a playground. And what we're seeing here isn't just about attitude, it's about legal control. The judge is reminding the defendant that even if he represents himself, he's held to the same standards as any attorney. But here's the twist. A self-represented defendant is a legal landmine. Without training, it's easy to cross boundaries, challenge rulings incorrectly, or say something that lands you deeper in trouble. And that's exactly what's happening here. Judge Simpson knows it, and he's laying down the law. Let me ask you, if you were facing jail time, would you risk representing yourself, or would you bring in a professional to defend your freedom? Let us know in the comments, because this is already heating up.
If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That concludes this hearing. Set a bond violation hearing, April 16th, 2024 at 2 p.m. At 2 p.m. Is there anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tether condition. Because this time, this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. Maybe, yeah, I can't afford cash bonds or something, just right, be around on maybe time that I've got it, you know.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges.
This is where things shift. The judge doesn't need a formal charge, just the allegation of a violation to move forward with a hearing. Legally speaking, conditional bond violations don't always require new criminal charges. The court is allowed to consider behavior, even if it hasn't gone through prosecution yet. Why? Because when you're out on bond, you're walking a tightrope. It's a legal privilege, not a right, and any misstep, even questionable behavior, can revoke it instantly. That's what's happening here. And Cody's already stumbling over his own defense, saying I wasn't charged won't cut it. The condition was not to commit a crime, and trespassing, charged or not, is still a crime. Quick poll. Should alleged behavior be enough to land someone back in jail? Or should the court wait for official charges? Drop your opinion. This one's debatable.
Okay, so, all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you. Court does call the case of the people state of Michigan versus Cody Lee Jolly. Your name, sir?
Cody Lee Jolly.
Okay. This is a bond violation hearing. Just go ahead.
Before we begin, I do have a copy of the police report outlining the violations, a copy of the complaint of violation release, and 3 photographs all to give to the defendant so that he could review them before. Like, there's a paper.
All right.
Thank you.
Mr. Jolly, you had an opportunity to look through all of that?
Yeah.
All right. So let me ask you this. Do you still wish to continue with the hearing, or do you wish to admit to a violation of your conditional bond? As the court understands that there would be 2 potential violations: the violation of the substance abuse or substance provision of your bond. The other would be not to commit any crime, as there is the crime of trespassing, which has occurred or appears to have occurred.
Well, question, I guess, then, but just if I wasn't charged with trespass and stuff, right? Because I've not been.
I understand that.
Okay, so then would that technically come into play as legally? As
The condition of the bond is that you not commit any crime.
Right.
Trespassing can be crime. Doesn't matter whether it's charged.
Okay.
It won't for the court's consideration.
Okay. Sure. Okay.
So what do you wish to do?
I mean, I don't, I guess I mean, I admit that there was probably weed on me that was still there. I didn't know that much weed on me. That was still there, and yeah, about the trespass, I don't know how it comes in.
Well, you had been read trespass before, correct? I mean, you don't have, pardon?
I never remember that.
So if the court understands it, correct me if I'm wrong, I mean, you can certainly look at it, that you had been read trespass from University of Michigan properties before?
I think due to this, I guess due to this kid ongoing case, because I have a
Right, but hold on.
They said that it's just this case. I'm
Right, but Mr. Jolly, my point is that you've been read trespass from University of Michigan, right?
Yeah, but I'm in court paperwork with them. I've argued it.
Okay, all right, then that's
Pretty cool.
all right. You want to go around and round about that? I will
It's okay.
necessarily go round and round about it. I mean, you admit to violating the substance provisions. You do admit to that.
Correct. And I was at the library.
All right. Pardon?
I was at the library.
Right.
Correct.
And would you admit that you shouldn't have been on the library property?
Yes. Yeah.
Because you had been trespassed before, right?
From the right. Yeah. All the stuff. Right.
Right? Okay. All right. So you're admitting to those violations.
Boom. The defendant just admitted to violating the substance provisions and trespassing. And here's the key legal insight. Once you admit to a bond violation, The judge doesn't need further investigation, just an official acknowledgement to act on. What's wild is how casual the admission was. First, he hedges, saying probably still there, then stumbles around excuses, and finally agrees. That's not a confident defense, it's a legal unraveling. This moment seals it. He admits he was on property he was banned from, and that he used substances against bond terms. That's enough for any judge to hit the brakes on freedom. Are you surprised he gave in that easily, or do you think he had no choice? Sound off in the comments, we're just getting started.
Nice of everybody to come down. All right, I will accept those admissions to that. Now, you wanted to argue your bond, sir, given the violations?
Yeah, my thing was just that, you know, still I'm going through the court process trying to get the trial. Already done 2 months on this tether. It's done over 2 weeks, done like 15 days so far in jail, and I haven't been to trial yet. So my hope was that with all that time served and not being convicted yet, that I could just go back and to being a regular citizen, treated fairly, and await trial.
All right, and I'll certainly hear from people, but here's the court's concern with releasing you. You originally were released on this case, right? And then shortly after being released, you're in violation of the conditions of your release. Right?
I don't know that. This has been 2 months.
Well, you just admitted to violations. Well, but you just admitted to violations, right? Right?
Right.
Okay. So what tells me that if I were to release you, that there wouldn't be other violations of your condition?
That's kind of what I'm asking, is that if you could remove the conditions, because I haven't still going through the court process. My thing is I don't have money to.
No, Mr. Jolly, you don't understand how this works. You were released, okay, with certain conditions regarding your release, right? Right?
Right.
Okay. So you were free to do what you needed to do as long as you abided by those conditions, right? That's where you were.
Right.
Then at some point, you violated those conditions.
Right. It's been 2 months.
Okay, but it doesn't matter. You violated the conditions.
Right.
Right? Okay. Now, Mr. Jolly, here's the problem. If you think for one moment that even if I were considering your release, that I would release you without any conditions, that's not going to happen.
Judge Simpson just dropped the gavel, metaphorically. He's drawing the line even if he did consider release. There is no way it's happening without strict conditions. And honestly, that's textbook judicial discretion. What's fascinating here is the defendant's argument, just take off the conditions. But in reality, conditions are the only reason many defendants are released at all. Remove those and the risk skyrockets for victims, witnesses, and public safety. And the judge? He's been watching the pattern. First, Cody broke release terms. Now he's pleading for freedom without accountability. It's not just a legal fail, it's a trust issue. Be real. If someone broke your rules twice, would you give them another chance or tighten the leash? Judge Simpson's answer is crystal clear.
I'm just trying.
So then the question becomes, Mr. Jolly, when you say you want me to release you, how can you assure the court that you will abide by the conditions that have been set?
Just the fact that I'm a law-abiding citizen, besides the fact that I'm guilty of this, I have no proof that I haven't been convicted, guilty of this, no proof that I did. Besides this ongoing plea, I'm a law-abiding citizen, so I just ask for being considered innocent.
Sir, you are considered innocent until proven guilty, but the court also has the ability to set your bond, and give conditions. All right. The court initially did that, and you violated those conditions.
Yeah, no, I understand what you're, I think a lot, I do my best when I get out, but that's when I get out, and a lot of my citizens, I don't.
Here's what I'm gonna do. Was there anything from the people?
A couple of things. So what I didn't realize, and I apologize, but I wasn't reading the report properly the last time we were here. It's 2 events that he's back at the library. So when I was speaking with the officer beforehand, they made that abundantly clear to me.
That there were 2 times that he was,
Yeah, and at 2 separate libraries. So I'm not really sure what's going on.
What do you mean, what's going on? Oh, are the things out there again? It was balloons? So there's this filter thing, and we're trying to figure out where it comes from. We'll sort that out. But the balloons are pretty, I bet. They were. Okay.
So it's 2 April 3rd, at 5:55 p.m. He was there. He was looking at according to the police report, he was looking at pornography at a public computer that he was suspected of masturbating. I asked the officer who's here to give me additional details about that. And I believe the information I got was that the witnesses believed he was masturbating, perhaps that his pants were in a certain position, that he was rubbing his genitalia underneath his clothes, which is similar to the events of the April 5th, in the sense that when the police get there, he's not actually exposed, but certainly conducting himself in a way where he's got his chest exposed, his outer layer of pants pulled down. And this is a CSC case. So it's like, when we take that behavior and then we layer it on with the fact that he's out on bond for assaulting nurses at the U of M hospital, and he's now charged with CSC for his sexual assaults on them.
This is where the courtroom gets truly disturbing. The prosecution reveals the deeper backstory. This isn't just about trespassing or a bond violation. This man is facing criminal sexual conduct charges, with accusations involving hospital nurses. And what's worse, he was already out on bond when he allegedly committed these new acts. That's a huge red flag in any courtroom. Judges consider prior behavior, yes, but ongoing behavior while under court supervision, that's almost always game over for the defense. Add to that a multi-state criminal history, North Carolina, Florida, and now Michigan, and it's no surprise the prosecutor is pushing to keep him locked up. Question for you. Do you think the system gave him too many chances, or is the judge right to draw the line here? Because things just got serious.
But in response to the I'm a law-abiding citizen, I mean, I'm looking at his criminal history from Florida. I'm looking at his criminal history from North Carolina. I'm looking at his criminal history from Michigan. The majority of what I'm seeing are misdemeanors, but I do have carrying a concealed weapon from North Carolina. There are larceny offenses from North Carolina. And well, there are. I'm not looking at them right now.
Sir, hold on.
In Florida, there is a charge of battery, touch or strike. It was a misdemeanor assault, is what I would probably call it here. Resisting obstructing the police, which is clearly listed as a felony. In Michigan, which seems to be his most recent history, it appears that substance abuse is an issue. In 2010, he was convicted of operating while intoxicated. In 2011, there's a minor in possession that is still listed as a bench warrant. I don't know what that's about, out of the 90th District Court. 2016, retail fraud conviction. 2017, a conviction for use of controlled substance. That looks like it was pled down from a possession of dangerous drugs. Is what it is initially entered at. But all to say that this is not somebody who has no criminal history. This person's criminal history spans across at least 3 jurisdictions. So, Your Honor, at this point, I'm asking you to not release him. I do also have a question, though, however, about the tether.
Yes.
What type of tether? Like, so I don't have notes from the person that arranged him did not put notes in his file. And when I look it up in GIS, you would see that it was technically part of the tether.
It is not a. It's not a GPS tether. He's simply on a scram.
Oh, thanks, Your Honor.
All right. Anything else you want to say? At this juncture, I'm going to continue the defendants, given the circumstances of this case. I will. The bond violation has been found, and the defendant's bond will continue as revoked. You were set for, I will review that again, but you're set for preliminary examination in this matter this upcoming Tuesday, the 23rd, so a week from today.
Final verdict. Bond revoked. Judge Simpson doesn't hesitate. After everything revealed, the violations, the admissions, the history, this was the only logical outcome. And notice the professionalism here. He doesn't shout, he doesn't argue, he simply says the facts and moves forward. That's courtroom control at its finest. The defendant might have hoped for leniency, but facts don't lie, and neither do repeated violations. Judge Simpson gave every opportunity to explain, and what he got back was contradiction, excuses, and blurred lines. This final call reinforces one truth. The courtroom doesn't care about theatrics, it deals in facts and risk. And in this case, the risk was too high. Let's hear from you. Was the judge too strict? Or did he make the right call? Drop your take below.
Pardon?
Do my bond on that day.
I will look at it after I hear testimony in the case. But at this point, your bond will continue as revoked. Thank you.
Thank you.
And that wraps up one of the most intense bond violation hearings we've ever seen. From courtroom outbursts and back and forth legal talk, to shocking allegations and a denied plea for freedom, this case had it all. Judge Simpson held the line, refused to remove bond conditions, and made it clear self-representation doesn't mean self-destruction is allowed. The defendant's behavior on and off paper spoke louder than his words, and the final outcome reflected that. With charges still pending, a history of violations and disturbing allegations involving multiple jurisdictions, this case is far from over. But one thing is certain, the courtroom has spoken. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.